Well, hello there and welcome. It is Sunday, and today I'm doing something a little bit different. I'm not talking about on passive. I know it is completely shocking. Today we are kicking off a segment that I started doing when I first came onto YouTube called Hey Hun, You Woke Up. And I'm adding on to that victim voices because I think it's very important for us to get stories out there from people who have actually experienced what it's like to be part of a multi-level marketing company. Hey, Fernando, how are you doing? Hey, Angel, how are you? Thank you so much for being here. And we have with us Beth, the Queen of Spade, but I also have two special guests with me. Doug Brooks, who is an attorney, and he has fought for many years against deceptive businesses. And I also have Dr. William Keep, who is a marketing professor who has served as now I'm going to get it wrong, expert witness. There, I remembered it. Woo, look at me go. Expert witness. And so they are here as well. And so I'm going to bring each of them on so that they can tell you more about themselves. And we will then get into kind of the meat of all of this. And what I would love for you guys to do is if you have some questions, write them down. And towards the end of the show, I would love for you guys to be able to engage. And if you have questions for Bill, if you have questions for Doug, to be able to ask them. And, we can find out from the experts like right now. Hello, Doug. How are you doing? And thank you so much for being here.
Well, thanks for having me, Yolanda.
You are so welcome. Can you go ahead and give the audience just a little bit of your background, because I really truncated it?
No, that's fine. Actually, I've been an attorney for about 40 years. Since the early 90s, I have among many other things, I have brought several class actions against multi-level marketing companies. I have also represented consumer advocates who have spoken out against multi-level marketing companies. And I have filed formal petitions with the Federal Trade Commission to improve transparency and regulation in the multi-level marketing industry. I am semi-retired now. I'm not looking to take on any cases right now, but I am continuing my pro bono work, advocating for better protections for consumers against these multi-level marketing companies.
And I am so glad that you are, and I really appreciate everything that you have done and continue to work on. Bill, thank you so much for being here. Can you go ahead and tell people a little bit about your background? Because I can never do it justice at all.
Sure. And let me just give a shout out to Doug Brooks here. He's a little modest. He actually participated in a case that continues to ripple called Omnitrition, Webster versus Omnitrition. And the appellate courts have relied on the good work that Doug and his colleagues did on that case. So I'm Bill Keep. I'm a professor of marketing. I've been a professor of marketing for about a little over 30 years. In the mid-90s, I was asked by the Department of Justice to assist in the prosecution of a pyramid scheme in Western Kentucky. It was called Gold Unlimited. And it was a successful prosecution that then got me to get calls from other prosecutors and from private cases, in some cases, where I would assist them. So I worked with the FTC, the SEC, the state of Kentucky, the state of Florida. I've been on some private cases. I've co-authored with the retired senior economist at the Federal Trade Commission a couple of papers on multi-level marketing pyramid schemes. And I've also written about 40 pieces in a website outlet called Seeking Alpha. And almost all of those are on multi-level marketing pyramid schemes.
And last year, wasn't it your college that hosted the conference that we were all on the steering committee together, which was Multi-Level Marketing, the Consumer Protection Challenge?
So it was, and thank you. I should give them a shout out. School of Business at the College of New Jersey, which is in Ewing, New Jersey, just outside of Trenton. The dean there was kind enough to support us, and the technology would support us. And then we were co-sponsoring this with a university in Ireland. And so we were pleased to do it and look forward to future events.
Well, thank you, Bill, so much for your time. I really, really appreciate it. And then last, bringing on Beth, the Queen of Spade, who is here with me about every single night as we talk about on passive, sometimes Zeus's Bounty, and then sometimes some other MLMs that, you know, people don't really know about. Last night, so Doug and Bill, that, you know, we talked about Princess House because that was something that I had on my list, and we just kind of dove into that last night. So Beth, thank you so much for being here. I always appreciate your time and your energy.
Thank you so much. See, everyone already knows me in the chat, but Bill and Doug don't know me. So I'll just give a little synopsis. I was in both It Works and then Sensi right after. I spent about a year in MLMs, and I left in 2018 and began my channel in 2019. And now here I am, and Alonda and I like to deep dive the crazy ones that nobody talks about.
There's just so many of them. So let me go ahead and I have questions for you guys. So we are here talking about basically how to say things that we all want to say about these companies that we find problematic, but to do it safely. And one of the things is, I know that I had, and I believe I sent it to you, Bill or Doug, I don't remember which one or both, but Beachbody had a non-disparagement clause. So what I would like to know is, what is a non-disparagement clause and why do some companies have them?
Maybe Bill, you do the why and I'll do the what.
Okay, you do the what first. I'll do the why.
The what is just non-disparagement clause is a contractual clause that prevents one party to the contract from criticizing the other party. They typically, you see them in settlement agreements where the parties want to resolve all the problems between them, so they'll include a clause saying that they won't badmouth each other now that the case is settled. But pure and simply, it's a clause that prevents you from saying critical things, even true things. This is not defamation. So defamation refers to just false statements, but a non-disparagement clause can apply to true things, but critical things.
And the why is important to the continuing marketing of the firm. Firms rely heavily on reputation. Multi-level marketing firms in particular rely heavily on word of mouth. And so to tamp down any positive, negative word of mouth, they'll use these non-disparagement clauses, which, as Doug knows, literally is asking you or requiring you to give up a constitutional right. And so our Constitution guarantees us the right of free press, or free speech, I mean, and this clause is a way to hem you in on that. But it's all done from a marketing perspective. You know, they don't want bad news out there. They don't want negative comments, or when Doug talks about the truth, what if the truth is that there was something going on that would be or could be considered illegal? And so we have thrown a blanket on that by everyone in this contractual agreement signing off on that clause.
Thank you very much. It's, just gives me a lot to think about. Now, in terms of non-disparagement, and they had us to basically keep people quiet and not say anything, you know, bad about the company. But what is the difference between, you know, non-disparagement, defamation, and slander? Because those are all, I hear this all the time. It's like, oh, you're just slandering whatever. or, somebody will accuse me of defamation. So how do we know whether or not we are actually slandering someone or committing defamation?
Well, slander is a kind of defamation. Slander is spoken words. Libel, you may have also heard, that's written words. Both slander and libel are within the category of defamation. And defamation is a false statement about another person or a company. So the key thing is there. It's got to be a false statement. It's not defamatory if it's true. Non-disparagement, as I said earlier, disparagement can refer to things that are true, but are arguably holding that the company in disrepute. So does that answer your question, Alonda?
Yeah, it definitely does. So, well, let me ask you this as a follow-up. If somebody is accusing a creator of defamation or slander, what is something that we can do, or even should we even try to combat if they make that kind of accusation? Because usually it happens in the comment section, after you create a video, somebody will say something like that.
I'll take it from a non-legal perspective, and then Doug can take it from a legal perspective. First of all, anybody can accuse you of anything, especially in a chat, especially if they're allowed to be anonymous. So we have, in the internet, we have multiple layers of permissions to abuse people, so to speak. And by that, I mean, when people are allowed to do things anonymously, that's a problem. And of course, accusing someone of defamation is not the same as bringing a lawsuit against them, right? So for me to throw out those kinds of words to someone actually isn't good in terms of other people reading it, but that is just not the same as somebody going after you with a lawsuit, right, Doug?
Absolutely, and I mean, I have seen, I have represented people who have been sued in court for alleged defamation, but many times the threats are made and they're never followed up on, and many times the threats are sufficient because someone receives a letter, a demand letter from a lawyer saying, stop defaming this company. And a lot of people are, they just don't want to be on the hook. So they'll withdraw whatever it is they said, or they'll stop saying it, but they'll shut up and they'll stop talking about it, even if what they said was absolutely true. The problem with our system, or the feature of our system, is that anyone can go to court and file a complaint, and the defendant, and you could be as pure as newly driven snow, but you're still going to have to spend money to defend yourself.
I'd like to follow up on what Doug is saying, because it highlights the inherently uneven playing field between a business and an individual contractor or an individual consumer. Businesses, especially businesses of any size, have lawyers. And so the challenge of getting their lawyer to write one more letter against a former distributor, for example, in the case of the MLM, or a current distributor, is no big deal. For that distributor to get that letter is a big deal. So for the average person, the thought of having to go out and find a lawyer and gathering together enough money for at least the initial expenses, I mean, even if you have a lawyer who's very sympathetic to your situation, we're talking about thousands of dollars. And so we have this inherently uneven field where you can be saying something perfectly true, even something that there's evidential supporting evidence, but if they can scare you away, they will.
And I think you said something very important right there, and that is to scare you. And I think a lot of times that's exactly what happens for content creators, whether you're on Twitter or you're on Instagram or you're on YouTube or on TikTok, wherever you are, they're looking to, make you kind of shake in your boots, so to speak. So,
Yeah.
what happens if you do speak out, but you've signed a non-disparagement clause and you go against that? I mean, can they come after you? What's the likelihood they'd come after you?
Could Beachbody sue Alonda right now for her channel, for example?
Well, I mean, the short answer is yes. I haven't thoroughly researched all the issues on this, but I found recently a recent case involving an MLM called Free Life, and they sued one of their distributors for setting up a website that criticized them. They invoked, they had a non-disparagement clause in their agreement. And this guy had signed up as a distributor, and that means, he's gone to the website and he's clicked on a box saying, I agree to all these terms. And the terms are, there's no negotiation over those terms. It's what lawyers call a contract of adhesion. It's a take it or leave it. And we check on these boxes all the time whenever you go to a website or you buy something. But at any rate, this guy had checked the box, and it turns out the contract had a non-disparagement clause in it, and subsequently the relationship broke down, and he set up a website that was critical of the company, and they sued him. And the judge, the district court judge, a federal district court judge in Texas, said that first of all, non-disparagement doesn't mean it has to be false. It can be a true statement. So even though what the defendant said about the company was true, that didn't mean it wasn't non-disparagement. And second of all, that what this judge said is that constitutional rights can be waived. You can agree not to assert your constitutional rights, and you signed a contract, and I'm going to enforce it. So here's a guy. I mean, that's the risk that Bill and I are concerned about, is that people sign these things. They have no idea what they're signing, and they may find out later on that that if the company decides they want to take an aggressive approach, they could be on the receiving end of a lawsuit.
Yeah, because when you go in to the E-suite to become a consultant for these companies, as soon as you click accept to their consultant agreement, in a lot of cases, you're just automatically agreeing to that non-disparaging. It's not like they completely explain it to you. It will be in small print. Most of us don't take the time to read it. Let's be honest. We don't read the policies and procedures in the small print. So I think it is true that most of us don't even realize that we're signing one of those when we become a consultant automatically with most of these companies.
Yes. I think that's right. And I think we need to at least accept some of that responsibility ourselves, right? I mean, if you sign a mortgage to buy a house, there's that mortgage document is going to be multiple pages long. And in some states, they've actually made a law that you have to have a lawyer as part of that process. Now, I don't think all states, but some states. I know I live in Connecticut, and Connecticut is one of those states. So the part of the responsibility is ours in that,
Mhm.
to be informed consumers. And the irony here a little bit is that you are joining this to pursue a business opportunity, and you have to have your business hat on. And in my experience and the things I've read in cases, multi-level marketing cases, is that's not usually the case. People at the point of joining are excited about the possibility of what could happen here, but they really don't have their business hat on. And those contracts not only include non-disparagement clauses, but often include forced arbitration, where you agree that if there's a difference between you and your company, you will go to an arbitration situation, and that you will not go to court. Arbitration is going to end up being a little more favorable to the company. You've given up your right to go to court. And so those are all, I think, real problematic and very common in this industry, which, I'll just add this last comment. What kind of a business feels compelled to compel you to give up your constitutional rights?
Yeah,
An unethical one.
makes you kind of go, So Angel asked this question: could a person caught up in a non-disparagement battle while telling the truth claim whistleblower status?
Well, let me try to deal with that one. There is no whistleblower statute that specifically protects multi-level marketing distributors. There is a whistleblower statute that protects people who blow the whistle on securities fraud, and so that's under the ambit of the Securities and Exchange Commission that deals with securities. I don't want to get too far into the weeds here, but the SEC does have overlapping jurisdiction with the FTC over pyramid schemes. Bill mentioned, I think, wasn't your Gold Unlimited? Was that an SEC case, Bill?
That was DOJ. I don't think it was SEC, but I was in an SEC case, International Heritage Inc.
So there is, yes, that's a very famous case, and that was theoretically a multi-level marketing company.
That was.
So if you were to complain to the SEC, you would have some protection as a whistleblower. Unfortunately, the way the statute is written, it seems to refer to employees and not to independent contractors. But I think you would at least have some protection there. There is currently no whistleblower statute with the Federal Trade Commission. There is a pending piece of legislation that it's HR 6093 that would provide a whistleblower procedure for people who make complaints to the Federal Trade Commission, and that statute would protect multi-level marketing distributors who make claims about their company. But getting anything like that passed in Congress today is really a tough battle. So I'm not going to hold my breath waiting for that one to pass. But it is encouraging, at least, that representatives in Congress are at least cognizant of this issue, and at least some of them want to do something about it. There is a whistleblower statute for the, or I guess it's another proposed statute for the Consumer Finance Protection Bureau. And there are some protections in specific areas, like under OSHA, which deals with workplace accidents and conditions. There's protection for people that report those types of violations. There's some protection for people who report civil rights violations like discrimination. But unfortunately, there's nothing that specifically protects multi-level marketing distributors who complain about deceptive practices by their company.
I'll add just a couple of things to what Doug's sort of a non-legal issue. First of all, a lot of people think of the SEC as dealing with publicly held companies, which would be correct. It's a good way to think about it in general. But Doug is right that the SEC has overlapping responsibility with pyramid schemes, and I am familiar with, and I know Doug is familiar with, pyramid scheme cases brought by the by the SEC that were not apparently publicly held companies. These were not companies that had already registered with the SEC as an investment, et cetera. And so if you were in doubt, the prudent thing to do would be to contact the SEC and just send a complaint there. They do talk to their colleagues at the FTC. So if it's not a publicly held company, you don't have to scratch the SEC off your list because they're also interested in pyramid schemes. One other point I just want to make, and that is that we're talking about anti-defamation or non-defamation clauses, et cetera. It depends on the words. In other words, I shared with a lawyer some language from an MLM company that spoke to, it was a non-defamation clause that spoke to making public statements. And a lawyer, a government lawyer said to me, just as an offhand, I'm not sure this forbids them from going to law enforcement. So those anti-defamation or non-disparaging, those non-disparaging clauses, the wording is important.
I'm glad you brought that up, because there's both the speech issue, the talking about, people who like Alonda or your colleagues in the YouTube world who speak out against MLM. There's that speech issue, but then there's also the issue of, do these non-disparagement clauses preclude you from going to law enforcement? And many of these clauses, if you read them literally, they would apply to that situation. Now that invokes another part of the First Amendment, because the First Amendment doesn't only protect free speech, it also protects the right to petition the government. So you've got another whole set of issues here. And I think I'd like to be able to say that there's a clear, unmistakable guarantee that you are protected if you want to exercise your First Amendment rights. But that unfortunately, not every judge in every court agrees with the idea that you can't waive those your constitutional rights. In fact, there are many cases that have held that you can. I would say that at least on the issue of going to the authorities to report violations, I think you're on a stronger footing than you are if you are just speaking out on a website or a YouTube channel. There's some public policy issues there that, you know, we want people to report violations of law. And then this right to petition the government to redress grievances, that is part of the First Amendment. The cases on waiving your constitutional rights talk about the need that waiver be knowing and intentional. And there's some cases that say you have to have had counsel. And so the use of these standard form contracts that you click through to agree to, you know, whether that would be considered a knowing and intentional waiver of rights, you know, is very problematical. I mean, I would love to take that case and for someone who is going to the authorities to report a violation. Unfortunately, I couldn't guarantee to them in advance that they're going to win. I feel very strongly that, and I would, you know, argue till my dying breath that shouldn't apply. But you know, there's thousands of judges in the country, and some of them might tell me I'm wrong. So it's a tough situation to be in.
Is there a time limit on it? Like if I sign non-disparaging clause like 3 years ago, is it just for life, or does it like run out at any time?
Sort of depends on how the clause is written.
Okay, so they have to put the time frame maybe into the clause. Is that,
you know, they could write it however they want to. There's no you know, there's no law that restricts them.
okay.
But the longer it goes on, the harder the problem is going to be for them to convince a judge that the judge should enforce it. I mean, someone you know, who was in an MLM 3 years or 5 years ago, I'd say they're in a better position than someone who just left 2 weeks ago.
Okay.
Well,
That makes sense.
also people who have signed non-disparagement clauses, and maybe they did so, like myself when I joined Beachbody, I had no idea that was in there. But let's just say that you do. How can you protect yourself if you sign this, or can you even protect yourself to be able to then speak out?
I'll give you a non-legal legal response, and then Doug will hem that in better. First of all, if you're going to talk about a company, you need to be careful with the words you use. When you get upset or angry or hurt by a situation, particularly a situation where there's personal relationships involved, like in an MLM, it's easy to let that anger come out in ways that I think can trigger a company response. You know, I've said a number of things about a lot of companies over the years, sometimes in writing, and I've always done it in ways that either raised questions or I softened my language with regard to what might or might not be going on. So if you come running out the door screaming and yelling that this and that is all true and that this ought to be shut down, sort of thing, I think you're drawing attention to yourself, and if you're not using your language carefully, you're much more prone to get a reaction. I think that, yes, I see that Jamie Smith said, in my opinion, I've used my opinion as well many times. And so I just think that word choice matters. And the other thing I would just say in general is, and so now I've been, I consider myself a critic of the industry now for 25 years. And Doug, maybe even a little longer, I'm not sure. I have gotten information from all kinds of sources, and I've shared I've shared information to other people without having to reveal sources. In some cases, I didn't even know the source. I got an anonymous email, let's say. Now, the key there, of course, is what kind of evidence do you have? And so, in fact, I think that that's really an important part of the consideration. You have to put yourself in the position of the person that you want to act, which maybe, let's say, the Federal Trade Commission. Well, the Federal Trade Commission is made up with a lot of lawyers and a lot of economists, and they're going to be looking for evidence. So that's part of it. And I just saw the note about what other phrases, I've used phrases like seems or maybe or other things that sort of qualify the comment because in some instances, I want to be careful that I'm not saying something based on information I have that is not complete. So someone says something to me and I was like, if that's true, that's pretty serious. And maybe it is, but I'm not going to run out and say that it is. And I think that's really important. Not just MLM companies, but companies are smart. They have smart lawyers. I've been in a position where I've worked with organizational lawyers in-house, and they have a job to do, and MLM company lawyers are going to do their job. So you need to be careful and think about that.
I mean, I would second all of that. I mean, that's you are there is a risk here. So whatever you're saying, you better have serious evidence to support it. You shouldn't be just repeating rumors that you hear from someone else. If you hear something, there should be is there a document, or is there an email, or is there can you get confirmation from another source? But you want to be as sure as possible about what you're saying, and I think I anecdotally I think that I'm seeing MLM companies being more and more aggressive in terms of looking at what people are saying on social media. I think the industry is waking up to the fact that there is this there are people out there that are speaking out and they didn't used to have to deal with this. When I started bringing class action cases back in the early 90s, a lot of victims of MLM didn't know that that there were other victims out there. The internet was very new, and people just hadn't discovered them each other. And my experience is once people did realize that there were other victims and they found each other, then more and more of them were willing to speak out. But now, because it's become so easy to find people of like minds, this is it's becoming a bigger factor, and companies are getting more aggressive in terms of trying to protect their reputations.
I would even go so far as to say companies are afraid of you. And everything Doug just said describes that transition from the industry controlling the narrative for decades, literally decades, to the industry feeling as if it's losing control of the narrative. Articles in well-regarded publications, not just the local newspaper written by a local journalist, but by serious journalists who have done their homework, who are working with national, in some cases, international publications. And what's tagged the anti-MLM voices out there. So the industry is scared that they will not be able to maintain the kind of tone about the MLM opportunity that they have maintained for quite a while.
There's another
Bill, I
thing
think-
I for myself speaking out.
Yeah, should be.
Bill, I think you, and I don't know if you can reveal this. I think you were going to talk with someone at the FTC about what their position was on non-disparagement clauses and whether there's anything that they are thinking of doing or can do or might do.
Right. I've had some sort of, I guess you'd call them off the record or unofficial kind of conversations, just because I wanted to learn more. So the person who I was talking to was helping me understand rather than telling me what the FTC is going to do next. But I'm like some of you, I am only beginning to learn how often people who are involved in the industry as independent distributors are asked to give up their rights. And so I said to the person at the FTC I was speaking with, I said, why don't we just pass a constitutional amendment that says no American citizen can be bound by contractual language that limits their constitutional rights? One sentence. I'm up for that. I don't think that's going to fly, apparently, for a variety of reasons. Apparently, we like to give up our constitutional rights in pursuit of something, not just in MLM, but other places too. But to go back more to this specific issue of non-disparagement, apparently that's also an issue in the franchising industry. Yeah. And I know that's an industry that Doug knows well. And so that could be good for us, because if the FTC has more than one industry where they're seeing a common problem, they may be able to come up with a solution that helps minimize the issue. And I just want to end by saying none of these problems ever go away. The best we can do is manage behaviors and language. And so I think that's what the FTC would like to do.
Fernando just asked, would this come up in an unfair contract?
Not if you sign it.
The problem is, we can say that it's unfair, but again, there's no overarching law that governs what is fair or unfair in the multi-level marketing context. In fact, even in the franchise context, the FTC's franchise rule governs disclosure. It requires disclosure before you buy a franchise, but it doesn't specify what terms can or can't be in a franchise agreement. I would love to see, and I've urged the FTC to substantively regulate MLM contracts, to prohibit certain types of compensation plans and certain types of clauses. But I think the best we're going to see from the FTC is some kind of disclosure. We've recently understand that they are going to be proposing a rule governing earnings claims, and we are hoping that and assuming that it's going to cover MLM. MLM, by the way, is the only business opportunity in the United States that is not subject to some type of disclosure rule. Franchises have to make disclosures before you buy one. Other types of business opportunities have to make disclosures before you buy one. But multi-level marketing has very good lobbyists, and they were able to get themselves exempted from these rules. But the FTC is trying again. In fact, there's going to be a virtual public meeting on Thursday, and they are going to announce this latest effort. So, in fact, those of you who are listening, you do. I think the deadline is to make a comment on this is Tuesday. You can go to the FTC website and submit a comment in favor of regulating MLM and in favor of better disclosure, better regulation. And I would encourage everyone to do that. And then, I mean, this issue of what terms are in a typical multi-level marketing contract, I think is something that we talked about, maybe including this in the next time we do one of these MLM conferences, which may be in a few months. But there are so many clauses that you see in MLM agreements that most people do not understand what they mean. These are very sophisticated commercial agreements, but the context that you sign them is very informal, and you're told, "Oh, you don't need a lawyer. You're only investing $50 for the starter kit. It's not a big deal." And then you find out maybe a year or two later that you've signed a 100-page agreement that has got not just non-disparagement clauses, but arbitration clauses, disclaimers, non-competition covenants, all sorts of things that maybe if you had a lawyer, you'd understand what you were getting yourself into. But you probably didn't even read it, or if you did read it, you didn't understand what it meant. Sorry to sort of go off on a tangent here, but it's a serious problem with this business concept.
I just saw the comment from Fernando about Australia. Fernando, we have consumer protection. We have some regulations to protect consumer contracts, but the MLM contract is not considered a consumer contract. Correct, Doug?
That's right. In fact, when we talk about it, I wanted to bring this up with the non-disparagement issue, but there is a federal statute that protects consumers who criticize products that they buy. In fact, the FTC is responsible for enforcing this law, and they have cracked down on companies that have put non-disparagement clauses in consumer agreements. But the law is very specific that it does not protect independent contractors. And if you're an MLM distributor, one of the things that contract says is you're an independent contractor. You're not an employee, and you're not just a consumer. You're theoretically a business person. So you're not protected by this statute that otherwise it does protect consumers who post, for instance, if you post a review of the lawnmower that you bought or something, or the washing machine, you are protected there. But it doesn't. That law does not protect MLM distributors.
That's so funny too, because when you think about it, the distributors are the main customers of the MLM. So it's just kind of funny to me that it seems to be in this gray area.
Well, what you're pointing out is exactly right. The industry likes it both ways.
Mm-hmm.
If a company gets accused of running a pyramid scheme, often part of that complaint will be that the company cannot demonstrate retail sales to a non-distributor customer base.
Yeah, you have to do the recruiting, right? It has to be based mainly on the recruiting for that.
So the answer the MLM and the Direct Selling Association make is that these distributors are customers.
Mm-hmm.
So when they want them to be customers, they want them to be customers. When they don't want them to be customers, they
And their
want
employees all of a sudden.
independent distributors who are signing contracts.
Yeah.
And so, yeah, it's and I think I just want to back up for one moment and just talk about what's the purpose of complaining? In other words,
Yeah.
if you're going to complain, whether it's publicly or to truthandadvertising.org, that nonprofit that does good work in this area, or the National Consumer League is a nonprofit that looks at this area a bit, or why are you complaining? What's the goal, right? Now, it could be just one event. Okay, you just want to kind of get it out there. But I can tell you that, if the purpose is to try to facilitate change, then the complaint behavior needs to be purposeful and well-informed. And so by that, I mean understanding where to complain, how to complain, and to understand that there are people that you can complain to that you may not think of. So, for example, if someone asked me who they should complain to, I'm setting aside the non-disparagement clause for a second. But if someone asked me who to complain to, I would say the Federal Trade Commission, of course, and I would copy my congressman and I would copy my 2 senators. And I would send a copy to the Attorney General of my state. Those are the people who can bring long-term change, whether it's change in enforcement or change in laws. If you wanted to also send in a comment to tina.org, tina.org it has lawyers on staff and they write letters to the FTC and others as well. But if we're talking about change, then in fact, we've got to get to people who can make change happen. And so the chief enforcement people, FTC, SEC, if you think that's appropriate, Attorney General's office, those are the chief enforcement people on misleading claims, possible pyramid scheme charge, misleading product claims. It may also be the FDA if it's a nutrition type product. In fact, the very first MLM post-World War II that is now owned by Amway called Nutrilite got in trouble with the FDA, not the FTC, because of their product claims. And that was way back in the 50s.
Could you also report to the CDC if you're finding like the illegal medical claims, for example? Does that help? Because I've done a lot of that, so I'm just wondering.
Yeah, I would go with the FDA. The CDC, I don't know if they have an enforcement arm, and they do a lot of research and they disseminate a lot of information, but I don't know if they have an enforcement arm. Do you, Doug?
No, I don't think. I think you're right. I think it's that the issue there should go to the FDA, and I couldn't agree with you more on every one of your points, Bill. On because it's just one of the frustrating things about what we've done over the years is the victims don't like to complain, and this just. Until a few years ago, the FTC, and you've analyzed these things, Bill, but they did consumer fraud surveys of different types of fraud, and they consistently found that victims of pyramid scheme type fraud are the least likely to complain about what happened to them, as opposed to other types of consumer issues. So that all of these agencies, and especially your elected representatives, need to hear from you. They need to know that there is a problem here. If people don't say anything, there's no way for them to know. And it's so easy to communicate with these folks because they all have websites. You can go to your congressman's website, and there'll be a form there that you can fill out online, and you tell your story. I mean, cut and paste whatever you wrote to the FTC. I hope you did write to the FTC. Write it. Do the same thing with your congressman. It's you know, the more people that do this, the better chance that something will happen.
Now, would it help to also write to the Attorney General in the state that the MLM is actually located in? Because, for example, I'm here in Canada, and I'm fighting a lot of these U.S. companies that have put, you know, headquarters also in Canada. So they're kind of in both countries, but the main headquarters is in Utah or somewhere in the States. So would it also be helpful if, for example, I wrote to the Attorney General in one of those, like in California, let's say, or?
Yeah, I think that would be very helpful. And as a citizen of the United States, I have to apologize to you for living in a country that is the world capital of an inventor of MLM.
Yeah, thank you for that.
Yeah, I agree.
It is harder here to fight it.
And I saw the note about making up a video about complaints. I certainly could work on that. Maybe Yolanda would help me or something. But the issue here, imagine, if you will, a political map or spectrum. So if we can assume that politicians want to be reelected, just as a baseline assumption, let's not assume that they're corrupt or that they want to take people's money or anything. They just want to be reelected. Okay. And I worked full-time for a U.S. congressman for a year. So it's a job, actually, getting reelected. It's a lot of work, and it takes a lot of money. Now, if that congressman happens to have an MLM headquartered in their area, then there are also employees of the MLM that are in that congressman's area or congresswoman's area, and those employees vote. So you have some members of Congress who represent areas that are deeply, deeply connected to the industry. You mentioned Utah. That's certainly one of them. I'm a native of Michigan. Western Michigan is the home base of Amway. I think Mary Kay is in Texas.
It is.
Yeah.
So now imagine, though, that, I mean, we have over 400 members of Congress and 100 senators. Some of them are very concerned about consumer protection. But here's the rub. And as Doug was just describing it, if I go onto the website of I don't know, congressperson in Illinois or something, the first thing they're going to ask me is, where do I live?
Yeah.
They don't want to hear from me. They want to hear from you, the citizen of Illinois who lives in their district. And so, although there are members of Congress I would love to have a 15-minute conversation with regarding some of the problems in this industry, it's not easy for me. And if they haven't also heard from their own constituents, they got other problems to solve. There's no shortage of problems that politicians are looking at, whether they like it or not. And so to have people who are voters and who live in the district express themselves is a really, really important part of the long-term change that could come that would impact this industry. And it makes the FTC's job easier if, in fact, they are being encouraged by some members of Congress to pursue certain enforcement actions.
Yeah, that makes sense.
And Bill, we definitely can get together in terms of creating a video. I also wanted to let people know on my community tab what I am planning to say to the FTC for the upcoming meeting. I have it there. And if you would like to kind of take that as a model, if you will, and then tell your own story so that you can make your own comment to the FTC for the upcoming meeting, by all means, please do.
I'm doing it.
Now, something else that I want to ask you guys is about SLAPP lawsuits and how they relate possibly to, this non-disparagement, to the defamation and all of that. I mean, nobody wants to be involved in a frivolous lawsuit, but it does seem sometimes that some of these, I have received cease and desist letters, and I know, Doug, you are very familiar with the ones that I have received, that it seems almost like that's what they're trying to go after is really a SLAPP lawsuit. Or am I totally, off in Never Never Land?
No, you're absolutely right. There are some states that have very good SLAPP statutes, and that stands for Strategic Lawsuit Against Public Participation. And what those statutes are designed to do is to protect people who speak out against fraud or misconduct or anything like that. If you are sued and you can make you can demonstrate that the reason you are being sued is because you have, say, criticized this company, you've exercised your First Amendment rights, you can file a motion to dismiss that case, and that forces, and I'm thinking in terms of the California statute, it forces the plaintiff, the company that's suing you, to come up with the actual evidence that they claim to have, and to demonstrate that they have a real case and not just allegations. And of course, many of them are unable to do that. And again, in the California SLAPP statute, if the plaintiff fails to make that showing, they can be responsible to pay the costs that the defendant incurred. Not every state has a SLAPP statute, and not every state that has a SLAPP statute has a good one as the California statute. And again, even with that remedy, you still need a lawyer to exercise that right. So you still have the problem. It may be somewhat easier to find a lawyer who's willing to take the case because of the availability of a SLAPP motion, and the possibility that the lawyer could recover their fees from the plaintiff as opposed to from you. But it's still, you still don't want to get sued in the first place. But there is that protection, at least in some states.
I just want to, because of something Doug just said, remind me, beginning in this year, 2022, California has a new law that limits these non-disparagement clauses. I'm not sure quite if it's been tested yet or how broad it is, but the state did pass a law to try to limit the impact of these non-disparagement clauses. And the other point I was wanting to make, I think we have kind of two kinds of interests in terms of complaint behavior in general. One may be a very firm specific interest. In other words, this company X, right? And I've talked to other people who have been involved with company X and some bad things going on. And then there's the overall dissatisfaction or frustration or concern about industry practices that are common across firms, et cetera. I think when people who have been concerned about a company have actively joined together, and I'm sorry, but I'm blanking on the company that sold black dirt.
Boo.
Okay. They caused the people who were critical of that company caused a bit of a ruckus. And I thought that was very interesting. But
You're welcome.
Well done then. But in terms of, and that approach can work with other firms as well, of course. But in terms of longer term change, because we have an industry that has been at it for a long time, they have their own congressional caucus in the United States. They have friends. One of their big friends in Congress is now a senator, Senator Blackburn in Tennessee, and so we're talking about formidable ties to the centers of power in certain states and certainly in DC. Doug and I and a few dozen other people have been doing this for a long time and trying to have an impact. And we certainly, in some ways, I think have, and other good work that's been done by other experts in a case like VEMA and Advocare and LuLaRoe. But the longer term change is the groundswell needs to be persistent and broad.
Yeah. You reminded me that there is a direct selling caucus in Washington D.C.
Yes.
Comprised of I don't know if it's 60 or 70 congressmen who are recipients of largesse from the well, they call themselves the direct selling industry, but really it's the multi-level marketing industry.
Mm-hmm.
The direct selling association is almost completely comprised of MLM companies at this point, and the true direct sellers are either they don't exist or they've left.
Yeah, even their board is composed of people that were either CEOs of an MLM in the past or they still are now. I also know that Trump, when he was president, a lot of his people were also very connected to MLMs and the high up lobbyists of the MLMs. And that was just insane to me to find out how connected even his party was to the MLM industry.
Well, Trump himself had there was an MLM called the Trump Network.
Mm-hmm.
And he was a spokesmodel for an MLM called ACN. He's actually being sued right now by the ACN distributors.
Yep.
But I think Bill's point is this is a politically connected industry, and they have lots of friends in high places.
Mm-hmm.
There are plenty of congressmen who are willing to go to bat for the industry. At this point, there is no congressman that has spoken out specifically against deception and fraud in the MLM industry. No one is speaking on behalf of consumers or victims in this area. And what I think Bill is saying is we need people to go to their congressman and this is a long game, and the industry has been playing a long game for about as long as the industry's been in existence.
Mm-hmm.
And we need to do the same thing, and we're very far behind at this point.
Yeah, just a couple of small points. In 1994, the two largest donators to the Republican Party in the United States, company donators to the Republican Party in the United States, were Philip Morris and Amway.
Mm-hmm. Yep.
The U.S. Chamber of Commerce has been tied to this industry since either the early 80s or late 70s. This industry has created multiple billionaires,
Mm-hmm.
and money is important, and money is used to scare people and to accomplish things, etc. But don't underestimate the voice of voters in expressing their concerns and getting their member of Congress, their senators, to move on something, particularly that is important to large numbers of constituents.
So would that be like the next best thing to do, is for all of us to kind of get our Congress people on board? Like, would that be the next good big step for our anti-MLM movement, if you will?
If you do nothing else,
Do that?
find your congressmen's and your state senators as websites and tell your story. It doesn't have to be fancy language. It doesn't have to be, you don't have to get into the technical legalities of it all.
Mm-hmm.
Talk about how you were recruited, how much money you lost, what happened when you tried to get out. And the key thing is to make clear that you want something to be done about this, not just this company, but this industry.
And I think that's really important what you said, that it doesn't have to be fancy, because I do feel like some people may be scared to go that way because they think they have to put some big fancy letter with a lot of legal jargon or something in it. So I think it's really important to put out there that it doesn't have to be that. You can just write them, tell your story, say, please look into these laws again.
Yeah, I think, and Doug, I don't know about this, so correct me if I'm wrong. If in fact you had a bad experience with an MLM and you wrote to your congressman and you said, without going into specifics, I certainly would encourage you to learn more about this industry and to work with the Federal Trade Commission. Would that violate a non-disparagement clause?
I certainly, if you're not identifying that your company, you're not. I shouldn't say that, because who knows how these clauses are written, but I suspect most of them would at the minimum would say they're dealing with statements that identify the company. So if you're just talking about the multi-level marketing industry, that's not going to be a problem. Notwithstanding that the dire consequences that I was talking about earlier in this live stream, I think I'll go out on a limb and say I think if you are petitioning your congressman about a problem, I think you are much safer than if, for instance, you're going on to a website or going on to a YouTube channel or something like that. There's much more protection for that kind of petition. But absolutely, if you're just talking about the industry in general, and you can tell your story without identifying your company. Use the phrase multi-level marketing, because that's, all of these communications get sorted and categorized and filed. And so when the congressman asks his aides, what are people complaining about? And they'll say, well, they're complaining about privacy. They're complaining about, auto repair shops, and they're complaining about multi-level marketing. I think that would be, just incredibly helpful.
I think that would be very powerful. Now, Bill, I know that I've been working with you. You've been writing a letter that basically we could all use kind of as a template, if you will.
Bill's been fixing my letter.
Yeah.
Complaining to the FTC, but I think it would be very valuable if we also created something that, and I can weave my story into it, to use as a model for people to be like, okay, take this, what is written, and now input your kind of story within it. Do you think that would be helpful for people?
Yeah, I do. What I'm finding with this, the younger generation, I'm of the generation, I still like to read. And, my students, they want to listen to things or view things or whatever. And I'm sure they're getting good information from that. I'm not actually questioning that, but I think it would be easier for me to get my students to watch a short video than to read a couple pages of text. So yes, and we can do both. And I think that, I want to make sure that even though Doug and I have expressed concerns and tried to talk about where some of the borders are, you want to be careful not to cross over. The anti-MLM movement and even voices that may not quite fit that category, I'm sorry, I just saw the note from Jamie, but the anti-MLM movement and the voices that have come forward, even if it doesn't quite fit that category, have and are making a difference, not just with the industry, but also with regulators. They're hearing that too. And so, the people who are expressing themselves through social media, that's part of it. But we need all those components. So expressing yourself through social media isn't enough if you're member of Congress and never knows. So we need all those. And I noticed that question from Jamie Smith. We're recommending not naming the company, particularly if you think that you've been constrained or by a non-disparagement clause in the contract you signed. Even if you haven't, of course, sometimes some countries will write you a letter, and threaten to bring a suit against you or something like that, even, as Doug mentioned earlier, if they really don't have a good basis for it. So it's a judgment issue, and it has to do with the language of the contract you signed. Doug?
Yeah, I agree. I mean, look at your contract and see if there's a non-disparagement clause. If there's not a non-disparagement clause, then certainly go ahead and identify the company. If there is, then the safest thing to do would be to submit a complaint without naming the company. But my feeling is, yes, use the phrase, whether you name the company or not, use the phrase multi-level marketing, because they need to hear that this is part of an industry. It isn't. We're not just talking about one company or one situation. There is I'll call it an industry of companies that use this marketing plan that results in basically a 99% failure rate. And Jamie, I think you're right. You're and a number of the questions that people are asking are prompting me to, and I think Bill too, that we need to give some more thought to this and try to give better guidance and clearer guidance. And
here's what I would do, Jamie. I would call the FTC, and I would not give the name if I didn't feel comfortable or if I felt I was being constrained by a contract, and I would tell them that.
Yeah.
Oh, that's a good point. Actually, say I'm writing you, and by the way, I might be constrained by this contract, would actually be really helpful, and bring up the fact that that's an issue as well.
Yeah, that's exactly what I was thinking. Which brings me up another question, because, and I believe I sent this to both of you gentlemen. Beth and I have been covering a company since, well, I started covering it in November, called OnPassive. And with OnPassive, you have to sign a non-disclosure agreement, which I am guessing kind of fits in with this disparagement and,
Are they the same?
reporting.
Is an NDA the same thing first? Let's just do that first, because I am interested to hear what the difference is, because some companies are doing NDAs now instead of the non-disparaging.
Well, they are two different things.
Okay.
I'll let Bill also speak on this, but typically a non-disclosure agreement refers to things that you learn as a distributor, that you're not allowed to disclose to anyone outside of the organization. For instance, many MLM companies are very careful about their distributor lists. Even people that you recruit, once you've recruited them, they become part of the trade secret of the company. And there's usually a clause in the agreement that prevents you from disclosing trade secrets, and that includes your downline. So the thing that they really don't want you to do is take your downline list and go to another company and recruit all those people into the other company. I mean, there are scores, probably hundreds of lawsuits around the country between MLM companies and their high-level distributors on this issue. Someone who leaves an MLM for greener pastures, and they try to recruit their downline to go along with them. So that's where I've seen NDAs crop up. But again, you have to look at the clause and find out what is it that they're trying to protect. What's the information that they don't want you to disclose?
Right. Now, I have another question that I don't know if it relates to that or not, but since we're talking about disparagement and defamation and all of that, now when Beth and I do our live streams about on passive, we're using their own content. We're using, videos that their members have created, or that the CEO, like his words, and we're having commentary about that. How does that fit in with disparagement and all of that?
Well, I don't know about the commentary part yet, but I have often used language from firms or the Direct Selling Association in what I've written, and I think it's the right thing to do. Doug may correct me and maybe help me out if I'm wrong, but I think it's really important. Words matter, and so we need to let people know the words that are being used by this company, and we can do it in a way that doesn't even require comment. Sometimes the words speak for themselves, and people just look at the words and go, "Oh my God, that's awful."
Yeah, I think on here on YouTube, though, in order for us to get out of getting like a copyright complaint and whatnot, then unfortunately we have to commentate.
Yeah. Right. And so whatever you need to do, I'm just reinforcing, I want to reinforce this notion that that the using other people's words against them. In fact, if you look at a complaint that's filed, often that complaint, that say in a class action or even in a pyramid scheme brought by the government, that complaint will often contain words from the company themselves. So that works. One last thing I wanted to, just because I saw that note from Jamie about income claims and health claims and giving examples, and crucial to name the company, etc. Try to think of this as a process, and that whatever you're communicating with the Federal Trade Commission, for example, initially, may or may not be the end of the conversation. So in other words, your need to give them enough information to make them interested, but that isn't necessarily the end of the line. And so you may have time to provide other information.
I think that's really important because I mean, this, you said it earlier, Bill, or maybe you did, Doug. I don't remember. I'm sorry. That this is a long game, that we're looking at this, over time. We're not looking for, wiggle your nose and boom, the problem is solved. We have to go at it knowing that it is a process, a step-by-step thing, which brings me back to the meeting that's being held this week by the FTC. This is why it's important for people like myself, like Beth, victims of MLMs, to speak out so that we can maybe have that first step, so that those income disclosures are more forthcoming than what they are typically.
Yeah, let me just reinforce that. Could you imagine one of the most positive things that could happen is for the FTC to be surprised of how many people were interested in this problem? That's one of the most positive things that could happen. And to show you how it works the other way, when the FTC was doing the rulemaking, the business opportunity rulemaking process that finalized in 2011, during that process, they got, I think it was 17,000 comments, almost all saying the same thing, and almost all from the industry. The industry, in fact, engaged in a letter writing campaign to influence the FTC, and it worked. Or at least it worked to a degree. They got what they wanted. I don't want to claim that that's the only thing that did it, but it certainly, I think, had an impact. Voices of concern, or even just voices of, I want to hear what the FTC is doing about this. The best thing that could happen would be for the FTC to be surprised by the magnitude of the issue.
That would be fantastic.
Yeah.
Because I think that would speak so much of, like, we really do have a problem. We can't ignore this anymore.
And I feel like part of the problem is that they don't understand how big of a problem it actually is.
It's hard.
Some of them do, but
it's hard to, yeah. I mean, Doug's right. Some do. It's hard to know what they know. They're very much, each government entity, each country's federal government does things differently. Here we have the Federal Trade Commission. It's a 5-person commission. It's appointed by the president. 3 of the 5 are of the dominant party, the president's party. Am I right about that, Doug?
Yes. So no more than 3 from any one party. Right. So as a practical matter, yeah, it's and now so we have a majority of Biden appointments on the FTC.
I don't know if that last one got approved by the Senate yet.
I don't know. Yeah, I've got to take a break for a couple minutes. I'll be back.
Yeah.
Thanks, Doug.
So the regular, I mean, the FTC, which I think it was formed in 1914 or whatever. I'm pretty sure 14. They have major things on their plate.
Mm-hmm.
They prevent mergers and acquisitions in the United States that could be harmful to consumers. Obviously, consumer protection is an issue. And consumer protection, I mean, there's credit card fraud, there's identity theft, there's a range of these things out there. So we're looking at it from a certain perspective as we look into the FTC, and the FTC has some pretty important and heavy issues. And of course, only so many staff economists, only so many lawyers, et cetera, to go around. And one of the things that why we think this long-term game is important, or to think that way, is I'll use the example of Burn Lounge. When the FTC brings a case against a company, often the company will settle and fold up its tent, right? It'll just go away, or it'll promise not to be an MLM, and it'll exist, but it won't exist like it used to. So a company like Vima or Advocare. In a very small number of cases, the company decided to fight in court. And one of those companies was a company called Burn Lounge. So the
I actually remember that company.
Yeah, the FTC brings the case in 2007. It takes 5 years for them to get a decision. The decision is the lower court finds a Burn Lounge to be a pyramid scheme. Burn Lounge appeals it, and it's 2 more years at the appellate level. So in 2014, the appellate court affirms the lower court's decision. So we're talking about 7 years to go after a relatively small multi-level marketing / pyramid scheme. 7 years. So it's a significant resource commitment. So that is an issue that itself, I think, is a problem. But I have been critical of the FTC in writing on a few occasions, but I don't underestimate the fact that they have a tough job to do.
I can't imagine having all those complaints come in and figuring out like what's going to take precedence. I mean, I would presume it has to do with volume of complaints.
I don't know how they make their enforcement decisions. I think sometimes the FTC has regional offices all over the country, and there's some folks in those regional offices that they're the ones that are really fighting the fight, and and they may if they're really motivated, they may push for to go after one particular company. Another thing that sometimes happens is that a state will be investigating an MLM. They'll realize that the MLM has a legal team that can dwarf the Attorney General's staff in that state, and that state will either try to get other states to join them, or and then bring in the FTC. And certainly, given that the FTC's expertise in prosecuting these companies, this happened, by the way, with Fortune High Tech Marketing. There was originally an investigation by I think it was Illinois or Kentucky, and ultimately there were 4 states plus the FTC that cooperated in a case against that company. That company, by the way, was very politically well connected. They had some former AGs on their board, and a lot of support. And that took quite a while to get that case together.
Well, I want to say thank you so much to both of you for being here, giving us your time. So very much appreciated. Is there like any final thoughts that you would like to give to the listeners so that they have like that one nugget of information that they can like take and use and apply right away?
I think what Bill said earlier is the most important thing: is get your tell your story to the FTC, to the SEC, and especially to your congressman. I think we just can't emphasize enough how important that is. That it's not enough. I mean, it's wonderful to go on social media and comment and talk, and that helps because people see it, people read it. Mm-hmm. But the people that make the laws and the people that enforce the laws need to hear this too. They've got a lot of demands on their time, and they've got a lot of people knocking on their doors that are paid to bring messages to them. They need to hear from the folks that are really affected by this.
And numbers matter.
Can I just take a moment to personally thank both of you for your work in this industry for the past 20, 30 years? You don't know who I am, but I've actually been following you for the last 5 years since I got into MLMs, started following and trying to figure things out. And if it wasn't for the two of you and a couple other people like Stephen Hassan, I don't think it would be possible for people like Alonda and myself to come out here and even have a voice and have a chance of being heard. And I just want to let you know that our community very much looks up to you both and appreciates everything that you have done and continue to do.
Thank you.
Thank you.
I just feel like sometimes maybe you don't hear it enough, but you are very, very loved over here.
I do appreciate that.
Very much so. And I really enjoyed this. And I hope that everybody who participated in the chat, that you learned something from it. Seems like you did. I think it was a great conversation and an important conversation.
Mhm.
And we have an opportunity this week for our voices to be heard by the FTC.
Yes,
So
please
be
take
sure,
it.
take the opportunity and tell your story ever so succinctly. You can use what I put together, model it after that.
I'll
But
post up mine
use your
tomorrow
voice.
too, so that you guys can have an idea of someone that's taken hers and remolded it as well. Just have as many examples as you can.
And it doesn't have to be long. It can be, I don't know how many sentences mine is, but I think it's like 8. I don't know. So it's not super long. But I had some points I wanted to make, and I made them, and I'm sure Doug did the same thing. So you don't have to use legal language. You don't have to be I'm just a citizen. You're just a citizen, and you got something to say.
And it's important.
Mm-hmm. Yeah.
Well, thank you everyone for being here. We appreciate it. And Beth and I will be back tomorrow to talk about, say it with me,
One
passive.
passive. Yeah, we did it right again.
Some more stuff that I have found out about it. And, it appears as if on passive is being used as a front.
Kind of like Zeus's bounty.
Yeah, just like that, which we talked about on Friday. So thank you so much and have a great rest of your day. And we will be back tomorrow. Doug and Bill hang out for just a minute, and Beth and I will say our goodbyes to you. So everyone else, have a fantastic day. And thank you for being here. Goodbye.
Thanks. Bye, guys.
Bye.